Yeah. Uh, you know, I know that in chambers, yes, and then the in chambers commerce conference, yeah. Um, I think there is something to the actual use of a judge's chambers. Now, there seems to be some sort of problem with you seeing crime and not enforcing the laws. Now, I know that I'm wanting to know where my sons are at. Oh. Now, the inchoate, partially, completely, imperfectly formed. The common law has given birth to three general offenses, which are usually termed inchoate or primarily crimes: attempt, conspiracy, and incitement. Oh. A principal feature of these crimes is that they are committed even though the substantive offense is not successfully consummated. An attempt fails, a conspiracy comes to nothing. Words of incitement are ignored. In all these instances, there may be liability for the inchoate crime. Now, let's say that this conspiracy of those in office that they don't want to enforce the laws, it comes to nothing because I decide to employ somebody to make sure that you never have any authority. Or these words of incitement are ignored. When you incite somebody to violence, now you're suggesting that I'm the violent individual, but isn't it violent on the part of law enforcement? Now, am I committing the inchoate offense? All right, there's no matured incident. Words of incitement. Oh, three different kinds of crimes that are committed even though the substantive offense is not successfully consummated. An attempt fails. A conspiracy comes to nothing. Words of incitement are ignored. Now, this inciting me to have to continue to inform you of the laws. Let's say you're in chambers as a judge. I send you some emails that have some videos that document the crime of taking my sons without any due process to their father. Coach, you decide to teach this little motherfucker a lesson and get him the fuck out of your county. I'm thinking that it's still a crime to conspire to deprive Americans of their rights. And it's still a crime to incite any sort of violence on any person's personal life because you, as the sheriff's department, decide that you're just not going to do what the law requires. Now, we have to have law enforcement in the United States. Don't we, as a population? But we don't have to allow law enforcement to make any decisions. Now, when you get that 911 phone call and you're informed of a white collar crime where there's a kidnapping of my sons because of your issuance of court orders that were not issued according to the laws. Exactly how do you respond to a kidnapping emergency phone call? You're wanting to incite me to violence because of your refusal to enforce the laws? Thinking that, look at that psychologist. Oh, there's a greater propensity that he will get, the independent mental health evaluation and assessment of a person's mental emotional condition is made by an impartial mental health professional, such as a psychologist or psychiatrist. Is it an independent mental evaluation if the public defender meets with the mental health evaluator without myself being there? Is it the independent mental health evaluation if anything is said about the mental health evaluation without me being in the actual presence of the individual as the independent mental health evaluator? Yesterday I got to do one of these independent mental health evaluations. Yes. And I asked the actual psychologist that gave me this test to do. Yes, we might look at it a little later. I said, well, why don't we look at the evaluation that the state is going to require if restoration is not enforced? Now, I would say that it is inciting to some sort of anger response for not recognizing the actual laws of the United States. Now, restoration opinion. Oh, here it is. Definitely has at least one of the charges a serious offense. Yes. But is it a felony or is it a gross misdemeanor? It, the following factors are related to the need of forced medication order. Mm-mm. Mental illness for which the first line of treatment is psychotropic medication. Yes. I have a mental illness for knowing that you served somebody other than myself. Is that right? That's what the public court record says. How could I have a mental illness for having that when the public court record says that you served somebody else? Based on these factors, it is my opinion that the probability of restoration would be improved and the length of time of restoration would be reduced if the court granted judicial authority to treat Mr. Budnick against his will if the treating psychiatrist deems it clinically necessary. Oh. But then discussion with Jack Range. Ooh, I needed to clarify some of Paul Budnick's statements. Oh. He has misconstrued the intent of the laws in order to bolster his own perceptions. Well, when I look at Exhibit B, Jack, Exhibit B says that somebody else was served other than myself. When I read Exhibit A says I was not given any due process. Exhibit A says that there's no signature of the petitioner. Exhibit A says that there's fraudulent statements where I was a credible threat. Now, for some reason, those in the mental health profession don't seem to read Exhibit A and B. Now, why would you think that it would be legal for you to issue a court order where there is no requirements of the law? The law requires the order to say if the respondent received notice of the hearing and by what method. If the law requires it to say that, and Exhibit A says that the law did not do what is required, how can you issue a protection order? I'm needing restoration. Oh, why would I need restoration when I can read what the instructions say? The law requires it. You didn't do it. You violated the law. Now, there's some question about basic educational. Yes. There's some reason why you're still enforcing a protection order where the law has certain requirements and you violated those requirements. You didn't give me 5 judicial days. Yes. You didn't require the signature of the protected person. This signature is different than the other signature. Yes. And you still are enforcing this 2-count criminal complaint because the prosecuting attorney won't remove it. Looks to me like it's an abuse of power. You can't issue this because the domestic violence alleged victim, right, doesn't have to appear in court for civil court proceedings. Ouch. You don't have to remove the decree of dissolution because she did or did not appear in court. Oh, she's a victim of violent crime, but it wasn't a felony. It was a gross misdemeanor. The allegation, my record's been exonerated, expunged on Guam. Yes, completely destroyed. You don't have a question about this writ of garnishment that was issued in Spokane County Superior Court? Yeah. I looked on there, and August 7th of this very year, somebody completely destroyed it. Yes. I looked at these destroying of records. Do I have to be informed that there's no longer a wage garnishment? Do you not know where I'm at? Did Superior Court of Spokane County not contact law enforcement and say, well, we've decided to completely destroy the court order requiring a garnishment, and we're not going to inform the individual known as the defendant, but we decided to do it without informing him. Well, what if I wanted it to be there? You didn't give any notice before you issued it. How the fuck would it be that I would want to keep it there? Now, did you actually garnish the wages of my wife that's abducted my sons? Because if you didn't, I'm going to sue you for that. Jane Doe, E-Tux. Did you destroy it because you didn't want her to have to pay? But you had no problem obligating me to pay since 2012? So let me see. You decided to destroy a court record? Yes. Well, you would have had no problem garnishing my wages for the last, 6 years. And then you didn't inform me that you were going to do that. Phew. Now, you remember this court hearing? Yes. And then you decided you were going to do this? And did you require the actual petitioner's signature on the dissolution, but you didn't require personal service to myself because she was not a victim of a felony? Pooch. She wasn't a victim of domestic violence. I was never convicted of any crime. Pooch. We had an argument. How is it possible that Spokane Superior Court decided to do what they did? Now, I told Clallam County destroy the protection order because, as the law requires, the respondent did not receive actual notice of the hearing. Since the respondent did not receive actual notice of the hearing, reasonable notice at least 5 judicial days before there was a court hearing, an opportunity to be heard. It was not issued in accordance with the full faith and credit provisions of the VAWA. That means there's a big question with the 2-count criminal complaint for a gross misdemeanor instead of a felony. Can you go right to the prosecuting attorney's office with gross misdemeanor? Now, I'm just wanting to know why Judge Rohr didn't destroy this case, pooch, and why it is that the Superior Court Commissioner, look at here, Superior, right outside the box, look at this, without a court address, without a telephone number, yes, issuing it for 10 years. Well, why the fuck doesn't Brett Baisden destroy it? You decided to destroy the garnishment of wages because you didn't want my wife to have to pay her fair share since she was employed, or considering the number of dependents that she abducted and kidnapped. You didn't want her to have that tax deduction every year. I told you about her personal taxes. For every time she deducted my sons off of her personal taxes so as to receive some sort of enlarged tax refund, it's not just abduction, kidnapping, it's tax evasion. Now I'm going to sue the state for destroying the garnishment of wages fiction, and not obligating Jane Doe to pay her part because you had no problem garnishing my wages without any due process before you issued the Superior Court ruling.